מאסר למדה באוקספורד ובקיימברידג' וכעת כותב לדוקטורט על קריאתו של פרופסור דיוויד קאץ באוניברסיטת תל אביב.
שעבר שדיברתי פה, אני הבטחתי שפעם הבאה אני אדבר בעברית. אני לא אתקיים היום, אני עדיין אגיד שפעם הבאה, תצאו עם זה אגדה.
זה סגולה שתחזרי.
כן, נכון, עד שאני מדברת בעברית. טוב, אוקיי. Miss Jones was born to Jewish parents in 1779. She married Mr. Robinson in 1797 at the age of 17. They were married in a church, by license, without the knowledge or consent of Miss Jones's father. Their 16-year marriage produced children, but for a reason we do not know, Miss Jones sought to end the marriage, and the case reached the Consistory Court of London in May 1815. The basic claim was that according to the 1753 Marriage Act, a minor needed parental permission to marry by license, and seeing as this was lacking, her marriage was invalid from the start, and hence eligible for annulment. Thus far, pretty simple. The complicating factor was Jones's Jewish parentage. The judge noted the complexity here. She certainly, quote, appears to be a Jewess, he said. At least she is descended of Jewish parents. That she continues so is not proved. Jones was born Jewish but married in a Christian ceremony. Her behaviour was not consistent with her supposed religious designation. There is no discussion in this case report as to whether Jones's behaviour constituted deliberate or de facto conversion. The only question considered was whether the general law of marriage applied in this case, given that Jews and Quakers were exempted from its terms. Did Jones's ethnicity as a Jew, or her religious performance as a Christian, define which law she was subject to? Judge William Scott annulled the marriage on the basis that Jones's participation in a Christian marriage service made her subject to the terms of such a ceremony. Another case similarly evoked this dilemma of judicial conceptions of Jewish identity, with practice, ethnicity and belief confused and overlapping. John King, a money broker, was called to the stand as a witness before Lord Kenyon at the Court of the King's Bench on Friday, February 20, 1795. He took his oath on the New Testament, but was later challenged as to whether he was in fact a Christian. He answered that though he was born a Jew, he had been a Protestant since he had the capacity to decide for himself, though he had never renounced his Jewishness. He further revealed that he married his first wife according to Jewish rites, and that he had never been baptized nor formally joined the established church. On this basis, the barrister argued he could not possibly consider such an oath obligatory. Yet Lord Kenyon accepted his testimony, relying on the personal faith declaration as sufficient basis that he felt bound by the oath. In both cases, ethnicity and practice conflicted. In the second case of John King, even the element of practice was not determinative. Yet the judge tended towards assuming a Jewish to Christian conversion expressed in actions. What the terse and dry court reports of these cases failed to convey is the gravitas and complexity of questions involving Jewish conversion, an issue which penetrated the heart of English and Christian identity in this period. As the two quotes on the slide suggest, Jews were objects of missionary zeal, and every conversion was a triumph. Yet apprehensions about the fundamentals of Jewish identity, historical tropes of the subversive Jew, and concrete evidence of reverted conversions made real Jewish conversions uncomfortable ground. Their unfettered lives in England were a proud sign of the dignity and toleration of English society. Yet in a period of uncertain political and religious horizons, with religious dissent multiplying and fluid international loyalties, conversion of the other, whether Jew, infidel, heretic or anyone else, was the surest sign of conversion of the self. External threats were seen as attempts to Judaize the English, an imagined metaphor which nonetheless affected attitudes to real Jews in England. The two cases I presented so far should be viewed as they would have been in their contemporary milieu, as part of a broader judicial process of resolving new situations created through the resettlement of the Jews in the mid-17th century. This process itself took place in an evolving social context in which attitudes to Jews were as variegated as fascination, obsession, revulsion, and oftentimes confusion. In the 1717 trial of Francis Francia, the defendant is clearly identified as a Jew in the court and in the court record. The Attorney General is careful to point out that, quote, the defendant lives in Plough Yard in Fetter Lane and goes for a Jew, end quote. And indeed, this case is frequently cited in the historiographical narrative about Jews being allowed to swear a court oath on the Old Testament. However, what is not usually mentioned is that the witness who swore the oath then gave evidence that Francia was born in Bordeaux and immediately baptized. This means that the proclaimed Jew, whose evidence will be heard on his oath as a Jew, had passed through a foundational Christian ceremony at his birth. Evidence like this would only feed the widespread Christian anxiety over the depths of Jewish deception, which could persist beyond conversion, and the perceived need for distance and distinction between the communities to control border crossing. If a baptized Jew is still a Jew, this adds a layer of complication to any assessment of conversion in court. On the one hand, the judge is bound to defend the faith of England, which necessarily entails a desire for the conversion of the Jews, but simultaneously he is conditioned to suspect any convert of insincerity and possible reversal. Perhaps this is why Mr. Justice Richardson, in Sells v. Hoare in 1822, set aside concerns raised about a witness's religious affiliation and accepted his testimony. The case report describes how the synagogue attending, and therefore apparently Jewish, Solomon Money, claimed to be the Christian Joseph Manning and gave testimony following an oath on the Gospels. The legal counsel for the defendant moved for a new trial on the basis that Money could not have considered himself bound by the oath. The judge, however, feared it would be, quote, productive of great danger and confusion if such affidavits were received, and he opted to accept the oath as a binding moral and religious obligation, thus avoiding the theological and legal quagmire of determining the status of a Jew's oath on the Gospels, or attempting to determine his religious status at the time he took the oath. The cases presented so far might indicate a static condition in which the state favours the promotion of the Christian faith and inclines towards its practice. However, I would like to highlight some other cases which reflect more of a process in the development of a judicial approach to Jewish conversion. I will describe a gradual shift in this period from a judicial default of promoting conversion and defending converts from parental pressure to a more conflicted attitude and reluctance to interfere in families, to an attempt to even be religion blind in judging family cases involving religion change. One of the earliest cases concerns the maintenance of the daughter of Jacob Mendes de Britta, who, quote, embraced Christianity and converted to Protestantism. Initially, she was awarded maintenance by the Court of Session Justice at the Cork County level. However, the Court of the King's Bench quashed the order on the grounds that the daughter was not, quote, poor or likely to become chargeable to the parish, end quote. This decision reflects a judicial willingness not to bring family and religious matters within the court's jurisdiction. However, there was public uproar at this decision, and a petition on the subject was reviewed at the House of Commons. Widespread concern at the ruling culminated in the 1702 statute requiring Jewish parents to support an apostate child. This act was actually only repealed in 1846. The question of parental support for converts was at the heart of the dilemma posed by such cases for English national identity. On the one hand, Jewish conversion to Anglicanism was highly desirable, perhaps even the fulfillment of the divine plan, the whole reason for the Jewish presence in England. In that regard, Jewish parents must not be allowed to dissuade their offspring through financial control. Legal sanctions against such parents are completely reasonable, given the role of the law in expressing and safeguarding English national character. But such actions contrasted other religious and national values about not compelling religious conversion and not interfering within families. Despite the parliamentary legislation, these values were given expression in the curious case of Moses Marcus. The Jewish-born Marcus petitioned the Chancery Court in January 1723 on the terms of the 1702 statute for the court to order his father to pay him maintenance. As he had been raised a gentleman, and since his conversion to Protestantism had been cut off from essential financial support by his father. The petition and the case report note the sincerity of his conversion and its roots in an educated decision. You can see here a quote from the petition. The said petitioner is now of the age of 22 years upwards, and being by such education become capable of judging of the true religion, and having diligently searched the scriptures and inquired into the Christian religion as well as the Jewish, and being convinced that the truth of the one and the errors of the other, hath from a full conviction and from a lively faith in God's mercies through Jesus Christ our Saviour, without any worldly views, but on the contrary well knowing he should thereby become the hatred and scorn of his parents and relations, who are all Jews, and with whom he was before in great esteem, and be cast off from his parents. The petition was designed to persuade Lord Chancellor Parker of his case, and it's noteworthy that Marcus argued for the careful consideration of his conversion, his official acceptance by the Church of England, and the rejection by his parents and family. He could not be making a clearer statement that he had left the Jewish people to join the English society and religion in their fullest sense. In response, the Lord Chancellor simply ordered the master to check the facts of the situation and set an appropriate amount of maintenance, which Marcus's father, Marcus Moses, would be required to pay. There was no discussion about the applicability of the 1702 statute, as it was apparently taken for granted. The approach to Moses Marcus is perhaps best understood in the context of an earlier case in which Lord Parker delineated his attitude to the obligation of Jewish parents to provide for their converted children. In Vincent v. Fernandez in 1718, a married 44-year-old Christian daughter of a Jew petitioned the Lord Chancellor for maintenance from her deceased father's estate on the basis of the 1702 statute. This case evoked an extremely strong reading and interpretation of the Act by Parker, in which he prioritised his national and religious agenda over an exact construal of the words. The Act stated that a Jew may not refuse their Protestant child, quote, maintenance suitable to the degree or ability of the parent and to the age or education of such a child, end quote. Fernandez's estate countered that the woman was no longer a child and her education was complete. She was married and therefore no longer dependent on her parent, and that the death of the parent rendered it impossible that he refused to support her. In stark contrast to the Mendes de Brita case, Parker was determined to interpret the statute strictly to protect the converted offspring from any financial pressure to revert to Judaism. He even expressed concern that the Jewish parent may place his assets in a secret trust which the child could only access if he returned to Judaism. Parker's self-conception clearly required him to defend religious boundaries, promote conversion in a competitive environment, and protect the converted child from parental pressure. He interpreted the statute as not requiring explicit refusal by the parent, and asserted that any disinheritance of a converted child must be assumed to be the consequence of the conversion itself. If the Jewish father does, by will, dispose of all his estate from his child, this is in law a refusal, and unless some other reason be made appear, it shall be intended because the child was a Protestant. The judge even positioned his decision in terms of natural law, which is important in comparison to later use of the natural to justify a quite different legal approach. I'll say more on this later. In the context of this case, it's clear why Parker's approach to Moses Marcus's petition is to order the maintenance from his father without question. Here the father is alive and therefore plainly refusing to maintain his Protestant child. Parker has already created the precedent in Vincent v. Fernandez that the child's advanced age is no barrier to the maintenance support, and Marcus's petition is therefore straightforward in comparison. The Moses Marcus case bizarrely continues, however, as it seems that Marcus oscillated between the two religions, receiving financial support from his father while behaving as a Jew, but then immediately returning to the courts to reinstate his payments when he returned to Christianity. This behaviour continued throughout the decade, with further court orders in 1726, 27 and 30 under Parker and then Lord King as Chancellor. We see a clear judicial willingness here to intervene in family relationships in the name of supporting the established religion. In contrast, Lord Chancellor Hardwicke seems much more conflicted in his comments over the complex 1737 custody case of de Costa Villarreal v. Mellish. This case involved Kitty Villarreal, who married Joseph de Costa and had 2 children, and then became a widower. Her children were entrusted by deed to her father, their grandfather. Kitty later converted to Protestantism and married William Mellish. In 1737, she and her children petitioned the court for custody of the children to return to her. Nonconformist educated Lord Hardwicke, who would later guide the Jewish Naturalisation Act through Parliament, and the 1753 Marriage Act, which made special provision for the validity of Jewish marriages, replied to the case in detail. The question of religion and the state versus the family's place in determining it is paramount in this case. It was not just a case of custody of the children, but a question of the rights of Jews to educate their children, standing in opposition to the opportunity to place them in a home of the established religion. Hardwicke's comments seem to indicate his reluctance to rule, that he would ideally like to be religion blind. However, this proved impossible when the dispute itself was rooted in religious difference. One account described how the grandfather refused the mother unsupervised visits, apparently for fear that she would try to convince them of the children of her new religion. The legal representative of the children urged the judge to consider the temporal advantages of living with their Christian mother and how the education in Judaism would affect their fortunes. Nevertheless, Hardwicke ostensibly prioritised natural rights, not religious arguments, in reasoning in his reasoning to transfer the guardianship to the mother, stating that he felt bound to place the children with someone whose duty it is, both natural and civil, to take care of them and who is of the religion of his country. As we saw in Vincent v. Fernandez, natural rights were employed to support family ties, but also to promote Protestantism. There, Parker said it was natural for a parent to pass his inheritance to his child, and only something as serious as apostasy could deter the parent from so doing. This supported his decision in favour of promoting the established religion. In Villarreal da Costa v. Mellish, Hardwick invokes natural law to support the mother's prior claim over her children, which also happens to favour the established religion. Although I'm slightly suspect of Hardwick's motivations here, as if the situation was reversed and the mother was Jewish and the grandfather was Christian, I'm not convinced that he would be so sure that the mother's natural right would prevail. Indeed, he says as much when he states that he has much regard to conscience, but that Christianity is the law of the land. Having said that, Hardwick actually rejects the mother's claim, thereby restricting the operation of the law to maintain converted children, and leaning towards less state intervention. He mentions that, quote, it was thought one of the hardest parts of the persecuting Protestants abroad, the taking away the children and putting them under a different education, end quote. He would apparently be willing to uphold the contract she made with her father, as he had not broken its terms, and therefore keep the children with their grandfather, were it not for their own separate petition requesting to live with their mother. Only on this basis does he grant the children their preference. It's reasonable to assume that he interpreted the children's desire to live with their mother as an inclination of their willingness to leave a Jewish household and to live in a Christian one. This would give him moral permission to do so without making the broader statement that the court would be in favour of removing Jewish children from their homes. Towards the end of the century, Lord Chancellor Thurlow was able to fulfil Hardwick's desire to be religion blind, in the case Delmer versus Robello, though the result was still in favour of the established religion. This was an inheritance case where the testator, a Jew named Robello, had left the interest on his estate to be paid annually to the children of two of his sisters. He actually had three sisters, Rain, Rebecca and Estrella. Rain had converted to Catholicism 28 years before her brother wrote his will. She became a nun, changed her name to Maria Hieronima and lived in Genoa. The will named Rain and Estrella as the two sisters whose children should receive funds from the estate. The children of Rebecca brought the petition to claim that Robello was clearly mistaken in his writing and to show that the testator was her, and he must have clearly meant that the children of the sister Rebecca, not Rain, should inherit. They tried to bring parole evidence to show that the testator was heard expressing his wish to give to the children of his sisters at Leghorn, where Rebecca and Estrella both lived. However, Lord Thurlow invoked the common law parole evidence rule. This prevented the introduction of additional evidence in order to suggest and then resolve an ambiguity in a contract. Without directly relating to the question of Rain's conversion, he would not admit any supplementary evidence, arguing that there was not sufficient ambiguity in the will to justify it. Notwithstanding Rain's change of name, Thurlow stated that Rain still existed as a person to be the recipient of the will, and as such there was no uncertainty about whom to identify as the benefactors. An additional objection was made that Rain's status as a nun made it impossible for her to have children, and therefore she could not have been the intended sister. The Lord Chancellor rebuffed this with the hypothetical that she could at any point leave the nunnery, marry and bear children who would then be eligible to benefit from the testator's estate. Thurlow's refusal to even discuss the likelihood that Robello meant to provide for the children of his converted nun sister over his Jewish sister's family reflects a 180-degree shift in attitude from that of Lord Parker and Vincent v. Fernandez in 1718. In this earlier case, the assumption was that if a Jewish parent disinherits a child, it must be because of religion. If this logic was applied to the current case, then the onus would be to prove that the testator did not mean his two Jewish sisters, rather the unlikely combination of one Jewish sister and one converted Christian sister living as a nun in another location. Despite his narrow focus on implementing the parole evidence rule, it cannot have escaped Thurlow's attention that he was refusing a request to disinherit a Jew who had converted to Christianity, or at least the potential children thereof. In this case, being religion blind and taking a narrow approach to the application of the law supported the established religion and again prevented a Jew from disadvantaging his converted family member. The cases explored here show how the courts provided a forum for the exploration and display of contemporary attitudes towards Jewish conversion. Justices were grappling with new situations which probed the foundations of the Anglican constitution, in which any mention of a Jew, either theoretical or real, evoked layers of theological, historical and sociological meaning. Jewish conversion merely added complexity, as anxieties over identities and border crossings were encapsulated in questions about how England was relating to its small but growing Jewish population. These themes are all present in the cases, though also present is a noticeable tendency to try to minimise overt religious factors in rulings, not to use the courts as some direct arm of the church, and to allow the freedom of conscience required for what was hoped to promote the genuine success of English Anglicanism, and by extension, Englishness itself.
תודה רבה.